So it's been a while since I updated this crim playlist, no? I've been uploading civil law and political law review playlists, pero 4 months ago pa yata yung last post ko dito sa criminal law. The reason being kasi tapos na yung crim law 1 and gusto ko sanang ihabol na tapusin yung civil law 1 bago ko i-rotation. And I wish I could update more often, but then I'm juggling a lot of things, and actually currently I'm going through something. Recently suffered a loss sa family, but we all go through something, and the important thing is, despite everything, just na magulo and all that, and things not going smoothly, importante we still have the drive to still study and prepare for the bar. Okay, so we stopped at, I think, homicide. So the next topic that we will discuss for this video is tumultuous affray. So what is tumultuous affray? Tumultuous affray is a melee or free-for-all where several persons not comprising definite or identifiable groups attack one another in a confused and disorganized manner, resulting in either death or injury of one or some of them. So there's tumultuous affray if there are at least 4 persons involved in this free-for-all. Okay? Nagkagulo na, nagkarambulan, yun. And because of the rambulan, di na alam kung sino yung nag-inflict ng pain kanino, magulo na, maraming tao involved, at least 4. So they're confused, hindi na ma-pinpoint kung saan galing yung injury, sino nag-inflict, kasi nga rambulan na eh. And in that chaos, 1 or 2 or all of them or some of them, at least 1, was either injured or killed. So if someone was killed in that free-for-all, in that ramble, then that is a crime defined in Article 251 of the Revised Penal Code. So yung pangalan ng crime is death caused in tumultuous affray, pag may namatay. So the elements are, it exists when at least 4 persons took part in a tumultuous affray that resulted in death, as implied by the use of the word several, which means more than 2 but not very many. So yung elements, there are several persons, at least 4, and they do not compose groups organized for the common purpose of assaulting and attacking each other reciprocally. Hindi siya pinlano na magrambulan sila. It just happened. Like, imagine this, for example, nasa club, tapos nagkaangasan, tapos nagkasuntukan, may kasama yung isang party, may kasama yung isang party, hindi na alam kung sino, baka pati kasama nila na inflictan na nila ng pain or ng injury, or baka yun nga namatay yung victim hindi dahil sa isang tao, baka dahil sa 2 tao, hindi na alam, magulo. There are several persons who quarreled and assaulted one another in a confused and tumultuous manner. Okay? Dapat confused, dapat para pasok siya dito sa crime na death caused in a tumultuous affray. Dapat hindi magulo, confusing. And because of this affray, someone was killed. And one element is that it cannot be ascertained who actually killed the deceased or the victim. Hindi na ma-pinpoint kung sino sa kaguluhan. The persons who inflicted serious physical injuries or caused violence, however, can be identified. Again, if may conspiracy, hindi siya tumultuous affray. Kasi sa conspiracy, pinlanuhan yon na sama-sama kayo eh. So, hindi tumultuous yung nangyari. Hindi siya tumultuous affray. Organized siya. Isang element dito dapat hindi organized. Kasi kapag may conspiracy, tapos may namatay, then it could be either homicide or murder as the case may be. As previously discussed sa video on murder-homicide. So, yun yung tumultuous affray. So, who are liable sa tumultuous affray? Kasi nga, diba, nagkagulo, merong namatay. Hindi na alam kung sino yung nag-cause ng death kasi nga magulo. Grupo-grupo niya eh. So, in case of death as a result of tumultuous affray, and the persons who actually killed the deceased cannot be ascertained, the following are liable. Persons who inflicted serious physical injuries on the deceased. So, hindi alam kung sino yung pumatay, pero pag ma-identify kung sino yung nag-inflict ng serious physical injuries, okay? Pag ma-identify lang naman kung sino yung ma-identify through evidence na nag-cause sila ng serious physical injuries doon, then, doon sa taong yon, then that person may, or those persons, may be liable for death caused in tumultuous affray. Hindi na aanuhin kung sino talaga yung i-determine kung sino yung nag-inflict ng death blow. Hindi na ganon. Dahil magulo na nga, kung sino yung nag-inflict ng serious physical injury, yun yung liable. If hindi alam kung sino yung nag-inflict ng serious physical injury, hindi alam kung serious physical injury mo, wala naman silang weapons, wala sa kanilang may weapons, baka talagang grabe lang magsuntok or something, di ba? Hindi na ma-identify. Then, all persons who used violence upon the person of the deceased are liable. So, kung ma-identify kung sino, di ba nagkagulo, kung ma-identify kung sino yung nag-inflict ng serious physical injuries, yun yung magiging liable. Yung mga nakigulo lang or nag-inflict naman ng injury pero hindi naman malala, hindi sila liable. However, if walang ma-identify na nag-inflict ng serious physical injuries, lahat ng gumamit ng violence doon, liable. So, ingat-ingat kapag mga ganyang sitwasyon kasi baka isipin nyo na hindi naman kayo magiging liable kasi yun nga, sa kaguluhan, hindi naman madidetermine kung may mamatay man dyan, bahala na. Kasi yung mangyayari niyan, pag andun ka and nakigulo ka rin, you can be held liable for the death of someone if someone dies there. So, yung dapat na gawin is of course awatin, wag nang makigulo. Kasi kapag nakigulo ka pa at may namatay, di ba? Kahit hindi ikaw yung talagang pumatay or wala kang intention na pumatay, but because you also joined in this tumultuous affray and you probably also used violence, is very subjective and very case-to-case basis. So, you may be held liable. So, that's 251, death caused in tumultuous affray. Again, sa definition natin ng tumultuous affray kanina, diba? Free for all, where several persons not comprising indefinite and identifiable groups attack one another in a confused or disorganized manner, resulting in death or injury. So, yung 251, pag may namatay sa tumultuous affray. Sa 252 naman, kapag hindi naman namatay, pero may physical injuries. May serious physical injuries. So, all those who appear to have used violence shall suffer the penalty next lower in degree than that provided in serious physical injuries inflicted. So, that's Article 252, physical injuries caused in tumultuous affray. Gusto nyo malaman talaga kung ano yung penalties kasi hindi ko na siya i-discuss talaga kung ano yung penalty. Nasa codal naman yan. Tapos, when we discussed crimlaw 1, I already taught you how to compute the penalty, how to determine the penalty. So, that's another video. Just look for it sa playlist. So, the elements of Article 252, so 251 pag may namatay, 252 pag may na-injure lang. There is tumultuous affray. A participant or some participants thereof suffered serious physical injuries or of a less serious nature only. So, pwedeng serious physical or less serious. Pag slight, hindi na. So, para maging liable, yung participants ng affray na to, liable for 252, dapat merong na-injure. Yung injuries na na-suffer dapat serious or less serious. And persons responsible cannot be identified again, and all those who appear to have used quote-unquote violence upon the person of the offended party are known. Kailangan known kasi kung hindi alam, edi hindi naman pwedeng bystander lang yung kunin mo. Dapat someone na nakigulo rin, and hindi lang basta nakigulo na nagmumura-mura lang siya dyan or nagta-trash talk, di ba? Kailangan meron din siyang overt act of violence that can be proved. So, hindi define the degree of violence employed as long as you employed violence. Whatever the means, whatever the degree, you may be held liable if someone is injured, suffered serious or less serious physical injuries, that's 252. And if someone died, you will be held liable for Article 251, which is for the death of the victim. Okay, so the next crime that we will be discussing can be quite sensitive, no? It's about suicide, trying to kill yourself. Trying to kill yourself is not a crime in the Philippines. Okay, you will not be held liable for it. Like, for example, of course, if na-consummate yung suicide, you cannot hold the person na nag-suicide as criminally liable kasi, death extinguishes criminal liability. How can he or she be criminally liable if he or she, already died? So, wala. If ever ma-survive man niya, walang crime. The crime sa 253, as the name itself, states, is giving assistance to suicide. So the person liable here is the one giving assistance. The person who attempted suicide will not be held liable. So it is the means of giving assistance in the form of arms or weapons. Okay, binigyan mo ng lubid, binigyan mo ng baril, binigyan mo ng knife, or whatever that is. Pwede ring poison or whatever. Offering any assistance then doesn't have to be something. It could be an intellectual aid or suggestion, whatever, as long as you give assistance, that there is positive or direct cooperation so that a person may be able to commit suicide, then that person assisting is held liable. There are two modes for giving assistance to suicide. First one is you assist. Second one, parang ikaw na rin gumawa. So, assisting another to commit suicide, whether the suicide is consummated or not, that's still a crime. Hindi mo pwedeng i-reason na, okay, nag-assist ako sa kanya na mag-suicide, tinulungan ko siya, pero di naman siya namatay eh. So, bakit ako liable? The act that is punished here is the act of giving assistance, regardless of the success of the suicide or its failure. Second is, parang ikaw na rin gumawa. Like, for example, someone asked another person to kill him or her. Diba? That's technically suicide. Pero kung ikaw, ginawa mo rin, that's giving assistance to suicide. That's another mode. Therefore, you will be held liable. So, you can be held liable by giving any sort of assistance, basically. whether it's something tangible or not, whether the assistance is tangible or not. So the next question is, what about euthanasia or mercy killing? It's different. Okay? Euthanasia is different from suicide. Euthanasia is the practice of painlessly putting to death a person suffering from incurable disease. So, in euthanasia, the person killed does not want to die. However, the family may decide, okay, for example, na coma na or something, a doctor may resort to mercy killing of the patient. Pero the doctor cannot make the calls himself. Cannot decide. It has to be like the guardian, the legal guardian, or the person having custody of the patient or his family. So there are people that may be able to. There are only certain people, not the doctor himself, who should have the authority to give that call, to make that judgment. Okay, so next, Article 254, Discharge of Firearms. So what are the elements of discharge of firearms under Article 254 of the Revised Penal Code? The offender discharges a firearm against or at another person. So dapat at a person. Kapag discharge lang niya, pero wala naman siyang tinutukan, hindi siya pasok dito. Kailangan sa element ng discharge of firearms, Article 254, tinutukan. Tinutukan at pinaputok. Kailangan kasi na-discharge, hindi lang tutok. Okay? Dapat may tutok and then at the same time, pull the trigger. Na-discharge. Di naman aimed yung sabi sa element discharge yung punishable act dito sa 254. Hindi mo siya masasabing attempted murder or homicide as the case may be kasi another element of this crime is that the offender has no intention to kill that person. Because if there's intention to kill, it could be attempted murder or homicide as the case may be. The crime is discharge of firearm as long as it is initially aimed at offended party. Even if the gun was not pointed when it was fired. So, discharges firearm against or at another person, pero hindi ibig sabihin na kailangan na tamaan or na pinaputok talagang ganyan. Pwedeng tinutukan tapos pinutok somewhere else. Pasok pa rin yan. Okay? So, pag yan, tinutok sa'yo, pinaputok somewhere, that's still discharge of firearms. Hindi kailangan ganyan tapos, missed or something. Because there's no intention to kill. Pero pag in-aim, tapos hindi na ginanon, tapos hindi na tamaan, pero wala namang intention to kill, alam niya lang na hindi ka matatamaan, di ba? Still discharge of firearms. Whether pagtutok niya, pinaputok niya agad, hindi tinamaan kasi intention naman talaga niyang wag kang tamaan, or nilayo niya, still the same. If in the discharge of a firearm, the offended party is hit and wounded, there is a complex crime. Diba? As discussed sa Crim 1 sa previous videos natin. Complex crime of discharge of firearm with, so depende kung anong injury, serious or less serious physical injuries as the case may be. Intent to kill or animus interficendi cannot be automatically drawn from the mere fact that the use of firearms is dangerous to life. Hindi masasabing, ay tinutukan ako, attempt to life na agad. Not necessarily. Kasi pwedeng tinatakot ka lang, pero wala naman talagang intention na patayin ka. So unless that intention to kill is clear, it's not attempted homicide or murder as the case may be. So of course, it is dependent upon the circumstances and the evidence presented. So again, there must be no intent to kill, and the discharge was intended, well, for another reason, maybe just to merely frighten or cause alarm to the victim or the offended party. If the discharge of the firearm at the offended party is coupled with intent to kill, of course, it's not discharge of firearm, which is a consummated act in itself, but frustrated or attempted homicide or murder, pwedeng din parricide as the case may be, and not merely illegal discharge of firearm. Okay, so now let's talk about infanticide. Okay, let me just fix a typo here. So infanticide under Article 255 is the killing of any child less than 3 days of age, whether the killer is the parent, grandparent, or any other relative of a child or a stranger. So basically anyone. Kung parricide is pumatay ng relative, ang infanticide naman pumatay ng bata na less than 3 days of age, regardless kung sino. Pero bakit kailangan specify dito kung sino yung person's held liable? Could be the father or mother of the child, whether legitimate or illegitimate yung bata, or any other legitimate ascendant of the child, or a stranger. So basically anyone, kasi kahit nga stranger pasok no? It's because mother and maternal grandparents are entitled to mitigating circumstances, and to clarify that even the parents themselves, even the grandparents themselves may be held liable, even the mother herself, diba, is held liable. Hindi siya excuse na, akin naman yan, I can do it, diba, bata pa naman, or 3 days old pa lang naman. So, they're still held liable. So, it is necessary that the child be born alive and viable, capable of independent existence para pasok siya sa infanticide. Kasi kapag fetus pa lang siya, ibang crime naman yon, and you guessed it, it's abortion. Pero for infanticide, since ito yung pinag-uusapan natin, the crime is infanticide if buhay nung pinanganak and less than 3 days old saka siya pinatay. Others who cooperate with the killer, pwedeng mother, grandparent, killing of a child less than 3 days old. So, hindi siya naka 3 days old, less than 3 days old. Pag naka 3 days na siya, then pwedeng parricide, murder, or homicide as the case may be. Pero infanticide siya kapag less than 3 days old. Yung nag-cooperate will suffer penalty for murder. I-check nyo na lang, pero I think mas mabigat yung infanticide sa murder. Okay. So, yung nag-cooperate dun sa, clarify ko lang, yung nag-cooperate dun sa pumatay, like for example, yung pumatay is a parent or grandparent, yung penalty nila is same of parricide, which is mas mabigat kaysa sa homicide at murder. Pero pag nag-cooperate, yung mga strangers na nag-cooperate, then murder lang yung penalty. Pero pag yung stranger talaga mismo, that's still infanticide. Okay? Kapag hindi nag-cooperate, kapag yung principal person liable, infanticide pa rin siya. As long as yung basis dito, yung victim is less than 3 days old. So, concealment of dishonor is not an exculpatory circumstance, but it's a mitigating circumstance. So, kung yung reason based on the circumstances na nag-commit ng infanticide yung mother, and the purpose is to conceal her dishonor, then the penalty is lower because it serves as a mitigating circumstance. Prison mayor na lang. If committed by maternal grandparents, its reclusion temporal mas mabigat. If the mitigating circumstance, hindi automatic if yung nag-commit is mother or maternal grandparents. They have to prove that the reason that they committed infanticide was to conceal dishonor. So, is there really dishonor to conceal? So, yan yung check ng jurisprudence dyan. So a delinquent mother must be of good reputation and good morals in order that concealing dishonor may mitigate her liability. So yun yung sinasabi ko. Is there really an honor? Is there really an honor to protect? Diba? Was there really dishonor? Because if hindi naman good reputation si mother, then parang hindi pwedeng gamitin to na circumstance. For example, if the mother was known to be promiscuous or is engaged in sex work business, things like that, then there's no expectation of an honor to protect. I'm not saying that these women are not honorable at all or that they are dishonorable or something, but yung law kasi natin very outdated na and very judgy. The RPC, it's not updated, it's very patriarchal, it's not so it is what it is. We're studying the law, we're not imposing our own personal opinions here, but yeah, for there to be unfortunately, the law has to determine whether you are a woman of honor or not, diba? So depends upon the court to see if based on the circumstance that a mother may be entitled to this mitigating circumstance of concealing dishonor. Okay, so next, Article 256, intentional abortion. Abortion is the willful killing of the fetus in the uterus or the violent expulsion of the fetus. May difference. Either kill it sa womb, kill the fetus sa womb, but not necessarily extracting it or manually extracting it, same thing, still abortion. So if expulsion of the fetus from the maternal womb, which causes the death of the fetus, it's abortion. If you just took something and that in effect killed the fetus inside your womb, then you're held liable. So the following are the elements. There is a pregnant woman. Dapat hindi pa naire. Kasi kapag naire na, infanticide na pag pinatay. Kapag buhay, tapos pinatay. Diba? Less than 3 days old eh. Pero pag nasa womb pa lang, that's not infanticide, that's abortion. So there is a pregnant woman and violence is exerted. Yung forcefully, pwedeng forcefully expelling the fetus from the womb or, doing something, employing violence that kills the fetus inside, diba? Could ram something in or whatever their methods are, I don't know. Or pwedeng administration of drugs or beverages that is known to cause miscarriage or death of the fetus inside the mother's womb, or that the accused otherwise acts upon such pregnant woman. So abortion could be intentional, abortion could be committed by the woman herself, the pregnant woman herself, against the fetus that she is carrying in her womb, or someone else. So the punishable acts are the use of violence upon the pregnant woman, or acting but without acting. So these are modes, punishable acts. Acting but without using violence, without the consent of the woman, such as administering drugs or beverages. Pwedeng may consent ng woman, pwedeng hindi. Acting with the consent of pregnant woman, regardless, doesn't matter ng whether there is consent or not. That's still abortion as long as the killing of the fetus was intended. Okay, and as a result of the above acts, the fetus dies. It's important that the fetus dies for one to be liable for intentional abortion, because if the abortion is not successful, then one cannot be held liable for intentional abortion. So the fetus dies either in the womb or after having been forcefully expelled therefrom from the womb. And of course, abortion is intended. So who may be held liable? Persons who intentionally caused the abortion. And even if even if the pregnant woman did not do it herself, if she consented thereto, she will also be held liable. So the pregnant woman will be held liable, and the person who helped will also, or did the abortion, will also be held liable. Dalawa sila. As long as nag-consent si woman. The only situation wherein the pregnant woman will not be held liable for the death of the fetus in her womb is if the intentional abortion was done by someone without her consent. So violence was used upon her, the purpose is to kill the fetus. So for example, the pregnant woman wants to keep the baby. For example, scenario, boyfriend, girlfriend, they're not ready for a child, and the girlfriend decides to keep the child. The boyfriend doesn't want the responsibility, uses violence upon the pregnant girlfriend, and then there was miscarriage. The fetus died. So who is held liable in this case for intentional abortion? Of course, just the boyfriend, just the guy. But if, for example, they cooperated or the pregnant woman also consented, then that's it. Another example is if taking of abortive fashion pills, for example, by the woman, so that makes the woman liable. Also, the person who sold or gave her the medication also liable for intentional abortion. So frustrated abortion is committed if the fetus is expelled but is viable and therefore is not dead. So there's frustrated abortion in this case. Okay, so if the mother, as a consequence of abortion, suffers death or physical injuries, dapat expelled is viable, therefore that's just frustrated kasi hindi siya consummated. Okay, but of course, may stages. But there is intentional abortion, consummated siya if the fetus dies. So kind of like murder, homicide, there are stages. Could be frustrated, it could be, I'm not sure if pwede attempted. Of course, pwede siguro attempted. If the mother, as a consequence of abortion, suffers death or physical injuries, there is a complex crime of murder or physical injuries and abortion. So, for example, in this scenario I gave, the boyfriend inflicted violence upon the pregnant girlfriend, kills the fetus, and in the process also kills the girlfriend, then intentional abortion as to the fetus, but murder as to the pregnant woman, or physical injuries kapag hindi namatay. If the woman turns out not to be pregnant and someone performs an abortion upon her, he's liable for an impossible crime. Hindi siya intentional abortion because there has to be fetus for there to be intentional abortion. So, impossible crime only if the woman suffers no physical injury. Of course, if the woman suffers physical injury, then slight physical injuries, lesser physical injuries, or physical injuries as the case may be. So, it's a totally different crime, but there's still a crime. In abortion, the fetus could not sustain independent life, so no legal viability. In infanticide, the fetus could sustain an independent life after separation from the mother's womb. So, pag abortion, pwedeng buhay tapos namatay, that's fine, pero cannot sustain an independent life, basically, kahit na ilabas. That's abortion. Kasi kapag sustaining siya ng independent life in less than 3 days old, kahit it's just a matter of minutes, that's infanticide, not abortion. I hope that's clear. If the fetus survives, in spite of the attempt to kill it or the use of violence, abortion is not consummated. Again, could be frustrated. If abortion is intended and the fetus does not die, it is frustrated intentional abortion when all acts of execution have been performed by the offender. So sa infanticide, yung fetus person na less than 3 days old, viable or capable of living separately from the mother's womb. Pero pag yung fetus na expel, tapos hindi niya kaya mag-survive ng matagal outside, kailangan niya pa rin na nandun siya sa womb ng mother, then that's abortion. So gestation period, no? Like 7 months siguro. Pag 7 months na, tapos in-expel, tapos buhay na na-expel, that's infanticide, namatay. But, capable of sustaining life. Yun yung differences to the victim. Kasi sa abortion, laging the victim is not viable but remains to be a fetus. So, as long as fetus pa siya at hindi pa siya baby or infant, diba? Pag fetus, abortion. Pag hindi, infanticide. Basta less than 3 days old. So, sa infanticide, yung mitigating circumstances as discussed, mother, maternal grandparents, as long as the purpose is to conceal dishonor. Sa abortion naman, meron ding mitigating circumstance, but yung pwedeng mag-avail doon is just the pregnant woman to conceal her dishonor. Hindi na yung maternal grandparents. Okay. Unintentional abortion. Ano ba to? Okay, so unintentional abortion naman, the elements are, there is a pregnant woman, of course. The violence is the violence is used upon such pregnant woman without intending an abortion, but because of the violence intentionally exerted, hindi yung abortion yung intention violence yung intention dun sa buntis. And because of the violence, the result of the violence is that the fetus dies. So either in the womb or nahulugan, was expelled therefrom. So if the pregnant woman was killed by violence, then that's complex crime again. Parricide, homicide, parricide or murder as the case may be. Or homicide, diba, if there's no circumstances. So violence here, hindi pwedeng daldal lang. Dapat actual physical force yung kinakwento. Hindi pwedeng psychological violence or things like that. But, we have VAUSI, but that's different. We're not talking about SPL here. But for purposes of Article 257, then, dapat physical force. So, examples. When the intention of the accused is merely to maltreat a pregnant woman, parang hindi naman para patayin yung fetus or para mahulugan yung pregnant woman, that's unintentional abortion. Hindi intention yung abortion, but abortion resulted nonetheless. When the accused was not aware that the woman is pregnant, when it is established that the accused intended to kill the woman, but there is no sufficient proof to show intent to cause the abortion, in which case he must be convicted of the complex crime of parricide with unintentional abortion. So, abortion practiced by the woman herself or by parents, that's Article 258. Elements are, there is a pregnant woman who suffered an abortion, and the abortion is intended and is caused by the pregnant woman herself, any other person with her consent, any of her parents with her consent for the purpose of concealing her dishonor. So, parang intentional abortion din. I guess the difference here is that it doesn't matter if if the abortion is successful, like, parang, inano niya sa sarili niya. So, pre-perform na yung abortion against herself. Of course, there's an intention to abort. Okay? Abortion by a physician or midwife and dispensing of abortives. So, I guess, dito sa abortion na to, ang difference niya sa intentional abortion is that sa intentional abortion kasi, you inflict violence or you take something or you forcefully expel from the womb, diba? Kina-clarify lang na hindi lang yung woman herself yung liable for abortion, but even the physician or midwife or person dispensing of abortives, nagbebenta, still intentional abortion. So, sinasabi lang dito sa articles ito na they are also liable for abortion. So, parang who are liable? Yun yung articles na to. So, again, inulit lang, the pregnant woman or anyone, any stranger, diba? Any person, whether without your consent, liable. Intentional abortion yun. Let's not be confused. Okay? Yung Article 258 naman just clarifies that even physicians or midwives or persons dispensing, okay, yung nagbigay ng mga abortifacient na mga gamot are also liable. To make sure they are also liable. So, physician, midwife, taking advantage of their scientific knowledge or skill shall cause an abortion to assist in causing an abortion, or a pharmacist who, without proper prescription from a physician, shall dispense any abortive. Abortion by a physician or midwife and dispensing of abortives. So, elements are pregnant suffered an abortion. Abortion is intended. Offender is a physician or midwife who caused or assisted in causing an abortion. Said physician or midwife took advantage of his or her scientific knowledge or skill. So, ito yung mga liable. Offender is a pharmacist, no proper prescription from a physician. Offender dispenses any abortive. I guess this also imposes a greater liability on them because, for example, if you are a doctor, you have knowledge, so you use that knowledge to do a crime or to perpetuate a crime. So, it's intentional abortion still, but there's a separate article for these persons, like the doctor, the midwife, persons dispensing abortives or abortifacients, to determine, hindi siya bagong crime. It's to impose a greater sentence. So, it says here that the penalties provided shall be imposed in the maximum period. Okay? But still, the crime is intentional abortion. So, sa abortion, isipin nyo lang, huwag tayo ma-confuse. Intentional abortion and unintentional abortion. So, merong mga taong entitled to mitigating circumstances. Meron namang mga taong may greater penalty. Sino yung liable? So, yung ibang mga articles dyan, just explains the liability. Okay, so we'll discuss duel and mutilation, yun. And then that would be the last part of the video. And then next video na yung serious physical injuries kasi mahaba-haba din discussion to. Okay. So, duel. Actually, very luma. May nagdo-duel pa ba? So, formal or regular combat previously concerted between two parties in the presence of 2 or more seconds. Ako kung nanood kayo ng John Wick, yun yung duel. Of lawful age on each side who make selection of arms and fix all other conditions of the fight. So, bawal yung duel, bawal yung ginawa ni John Wick, kung ginawa nila sa Pilipinas yun, they will be liable for Article 260. So the modes are killing one's adversary in duel, or inflicting upon such adversary physical injuries, or making a combat although no physical injuries have been inflicted. So, hindi ko na masyadong explain, but yeah, kung nanonood ka ng John Wick, ayun, parang ganun yung duel, yung John Wick 4. So, yung liable sa duel is the persons involved. Okay? Persons who killed or inflicted injuries upon adversary or both combatants. Dalawa sila. The mere participation sa duel is a crime. And accomplices nila yung seconds. So, seconds is yung parang referee nila. Ganon. Make the selection. Sila yung, yun nga, dun sa movie, di ba? Pinapili sila kung anong gagamitin nilang weapon. Yun yung mga ginagawa ng seconds. They assist. Parang referee. O, ano pipiliin yung weapon? Para fair daw. Ano yung conditions? Saan? Mga ganyan. So, they are accomplices. If death results, so the mere, yung pinipinalize dito is the mere participation in duel. Now, if someone dies, then that is homicide. Can you invoke self-defense in the duel? Of course not. Kasi, you participated in this eh. Will it ever be murder? No, it won't. It's just homicide. Kasi pag murder, dapat may aggravating circumstances. And, hindi mo masasabing self-defense kasi, alam mo yung pinasok mo eh. Pwede siyang maging murder kung attended by other circumstances, pero generally. But, yeah, it's murder if it's attended by special aggravating circumstances. But, yeah, mere participation to duel, and you cannot invoke self-defense, of course, because you knowingly put yourself in danger. So, challenging another to a duel, or inciting another to accept a challenge to a duel, or scoffing or decrying another publicly for having refused to accept a challenge to fight or a duel. Basta, ni-induce mo siyang, wala pala eh, hindi ka pala matapang eh, ganon. Diba? That's scoffing or decrying another. Ano ka pala eh, duwag ka pala eh, mga ganyan. So, that's also a crime. So, yung challengers niyan, and yung instigators, they're both liable. Oh, never mind. I will discuss mutilation na lang pala when I discuss serious physical injuries. So, magkakasama na sila kasi mutilation, serious physical injuries are related. Less serious physical injuries, slight physical injuries in one video. So, yeah, good luck with your studies, and I hope that you found this video useful, and happy at it.